the whole business with Hartman, who's a very hard sort of man. He's almost well named. When he went in the room, he didn't have to approach anybody. But he went in fearlessly and arrogantly and went right up to somebody who was holding a hammer and said, "Put that down." And now he wants, I think on the prompting really of the prosecutor and GE, he wants to say that John Schuchardt turned around, raising the hammer toward him, and put him in fear. Whereas he's conceded from the beginning, he was never in fear. And I can't see the man being in fear of anything. I don't think he has the personality. But certainly you don't approach somebody who's holding a deadly weapon, quote, and tell them to put it down or you're going to break their jaw, which is about what he said to the man. So I'm not at all concerned about Hartman's testimony. I don't think there's a jury in the world who would convict on that kind of testimony. But I'm concerned
why the district attorney
would pursue it.
Pursues it.
Yeah, because Hartman at the preliminary hearing, in his demeanor and all the things that contribute to testimony and evidence, indicated he wasn't afraid of anything. I think the magistrate made it clear when he dismissed the aggravated assault charges, he was saying there was no weapon, there was no assault here on Mr. Hartman, and I think the district attorney has just reinstituted those charges because there are no specific findings at a preliminary hearing. So
How is that a preliminary hearing?
The preliminary hearing.
How does it?
Okay. You want to get over here?
I know you don't have it.
Yeah.
Maybe Ramsey does, our discovery motion.
I looked online, I can't find it. Yeah. Ramsey must have it.
Royce.
Yeah.
He apparently is going to be a witness of.
And he's a new name.
I never heard of him.
Yeah, I think
He asked during the informal discovery what witnesses they were going to call, what statements, and they gave us the statements of 5 people.
Yeah.
The other fellow, the guard, Goldman.
We'll do that over again when you do it.
Okay,
sure.
Yeah.
You two, it's fine.
Move around, that's good. Why don't you leave it where it was, Mike? You
Yeah.
don't have to go over to it.
They like the candid.
We need a little motion once in a while.
Sure.
You know, it's always
Okay.
talking heads. So when we're running and you're running, tell us you're ready.
We're running.
Okay, Marianne, are you ready?
Does it take running?
Yeah.
Actually, yeah.
Okay. Always look at it.
Yes. I asked a question about the preliminary motion. You're not about that. But
Okay,
how does the preliminary? What validity does the preliminary motion have in undermining the latter testimony of the guards?
The preliminary hearing in our procedure, and commonly in any other jurisdiction, is that stage after you've had a preliminary arraignment where you tell the people what they're charged with. And then in our jurisdiction, within 3 to 10 days, they're entitled to a preliminary hearing so that you don't hold them endlessly for charges that there may not even be a prima facie case for. Prima facie case is a term of art that means there's some evidence to show that you probably did what you're accused of. And later you'll have a trial, which we're having now, where the state is put to the burden of proving beyond a reasonable doubt that you did what you're accused of. But at this stage, it's simply to show that there's some evidence to show that you probably did what you're charged with. So at that hearing, you have certain rights under Pennsylvania law and under federal law that allow you to cross-examine their witnesses and put on witnesses of your own if you like. It's not usually a good tactic, and we didn't do that. But you certainly have the right to cross-examine people who are saying that you assaulted them or any evidence that's put on.
Did you cross-examine?
We did, yeah. We cross-examined.
And what value is that testimony? Is it under oath?
Sure. Everything's under oath. Everything's in a formal, semi-formal proceeding. A lot of the rules don't seem to apply the way they should. But and magistrates in Pennsylvania are not trained in the law. They're not lawyers, let alone true judges. So that, in my experience, they tend to hold everybody over for trial is a term they use. He's held for court. And then it's up to the district attorney, because we no longer have grand juries, to decide whether or not you should be the equivalent of indicted, so that an information would be filed, which is a formal accusation that you've done these things that you're charged with.
I think it's significant here. We had a district justice or a magistrate that had some integrity. The charges brought by the district attorney's office originally included such things as aggravated assault, terroristic threats, recklessly endangering another person, all crimes of violence. in the usual course of events, a magistrate, frequently guided by the recommendations of the district attorney's office, will send all of that to court, letting the district attorney sort out which he wants to move on. Here, the district justice threw out 5 of the 13 charges, including those ones I just mentioned, because there wasn't a scintilla of evidence supporting them. Not only could the Commonwealth not make out a prima facie case, there wasn't any evidence at all, which shows you something about the district attorney's motive in bringing the charges in the first place. This, I think, is significant because then when the district attorney returned informations, they put in counts which included the inflicting of bodily injury on 2 individuals at GE, later, in response to one of our motions, acknowledging they had no such evidence of any harm being caused to anybody. They put in a count that obscene gestures were used in support of a disorderly conduct information, later admitting in response to our motion that they had no such evidence of anything like that.
And even the judge struck those charges. I mean, I saw reported in the paper that all our motions were denied. Well, actually, they weren't. These counts in the different informations were dismissed. But what the value of the evidence at that hearing is that provides a basis for cross-examination now at trial, because it was given under oath. Mr. Hartman, alleging an assault, will now be put to the test again. Mr. Cox, whose job was on the line, standing at the door, letting people filter in without stopping them, his testimony is under scrutiny again. And I think he has to look Father Carl Kabat in the eye and Sister Ann Montgomery and say, looking down at them, yes, I say that you pinned me against the wall, and see if he doesn't turn purple.
Well, the problem at this stage is, though, he's already said it under oath once. He's got his employers looking over his shoulder, and he's got a problem.
Well, he's under a lot of pressure. The other names that are used, Mike, in the district attorney's opening statement. Now, we filed a discovery motion.
And we also, in our informal discovery, asked Bruce, if you recall, what witnesses he had, what statements he had, and he provided us with a list of statements. One named Leon Simmons, I think, appeared in one of the police reports. He's the guard that escorted Carl Kabat out, and his testimony really isn't crucial. No. But Howard Ruish, I don't know if you remember hearing his name before.
I don't remember his name until the statement by the DA.
And I think the DA mentioned that he would be a witness to the Hartman incident. So this, in my view, is the first time we've heard the name. We don't have any statement by him, even though we asked for them. And I think we ought to, when he is called, ask for an offer of proof. And if the district attorney intends to call him, ask why we weren't given his name before.
And his statement, because usually what these people say at the time of the event is important, because that's when it's supposed to be fresh, that's when they're supposed to be thinking about it, it's supposed to be keenly in their minds. And for them to come forward 6 months later is very prejudicial to us, because the whole thing could be very contrived, and we just don't know how to test his candor at this point. It's going to be another guard, it's going to be another fellow employee, it's going to be somebody who has an interest in bolstering GE's reputation here, because General Electric is very embarrassed about this incident. To let 8 people just run into their plant where they make nuclear warheads is very embarrassing. The FBI was livid. The FBI came to this office, the very office where Michael's sitting, and sub rosa, supposedly, between you and me, they were saying, look, all we're really interested in, and we would give an interview to the defendants and maybe work something out, is if we could find out how they got in the plant. Because that to us is a matter of national security, and we know that these good people are interested in the, as patriotic individuals, would want us to know that. A certain amount of naivete there. But in any event, I remember the agent coming over, Chuck, somebody or other, and proposing that we let him interview all of the defendants about 2 weeks after they were arrested, and they were all in jail. And were denied bail on his say-so. He's the same guy who denied them bail, and now he's being friendly Chuck, who just wants to know how they got in the plant, because that to them was the only issue. And I think that's why they never pursued it, really. To prosecute these people meant nothing to the federal authorities, because it was just an embarrassment, to everyone concerned. I think the FBI felt some fault that they had not looked over this plant to see that it was not secure. GE, really, it's just a nightmare that they wake up with every day and think, you know, what do we care about $27,000? It's nothing in terms of our billions of defense budget money that we've gotten, our overruns, our cost overruns that fill our pockets. And if they just leave us alone and you know, drop this case, plea bargain, do anything. The district attorney was well aware that they would give up their, quote, restitution if we just, quote, cop a plea and run away.
Why wouldn't the defendants do that?
The defendants had no interest in quote, copping a plea because they came here to give a message to the people of the community and to the people of the country. And I think they felt that that just would dishonor their message. They didn't come here looking for a secure way out. They came to speak to people. And I think that although I, as an attorney, was very concerned about their safety and about the fact that they may end up in state prison, and we don't have any white-collar prisons in this state. We have very rough institutions. So that if they go to a state prison, it's a memory that some of them may not even live to carry very long with them, because these people are not young people. And it means that they would go for more than 2 years, because otherwise they'd stay in the county prison. The local judges have made it clear no one's going in their county prison. It's crowded, it's expensive, it costs the county money. Many of the reasons for throwing these people out without bail, the last 4, really included the fact that the county didn't want to feed them anymore, didn't want to pay anymore for them. And so that my concern is that they could end up in state prison. But the defendants are not concerned about their personal safety. The statement in the Catholic Worker, immediately after this incident by Daniel Berrigan, a very long article, I think says it all. It's, please, you friends of ours, do not approach us, do not ask us to do something that will help ourselves, to save ourselves. We're not here to save ourselves. We're here to save you and your children. And I think that they weren't interested in what would have made their burden lighter. And I finally came to see that. And I think for Michael and me, it's been a very torturous kind of experience, because the closer you get to them, the more you feel.
I don't think they could have ever had the impact in accepting any type of a plea that they're having now in pursuing a trial of this case, in presenting a defense, in hopefully presenting a defense of justification. I think that what they came here for and the message that they wish to bring to the world can only be given in a trial in which they suffer extreme jeopardy, in which they're willing to suffer. They've already told the jury that they're not here to seek to get off. They're here to present testimony about the impending nuclear holocaust. And if they can do that, although as an attorney, you may have ambivalent feelings about the security of your clients, I think they will have done a great service to humanity. But we'll see how far that gets.
As of today, do you see any possibility of reversible error so far on the part of the judge or in the court or in the conduct of this proceeding?
Well, my personal feeling is that if we put everything on the record that's been said so far, and a certain amount of it has been said in chambers, and I think we have to get that on the record, this judge has a preconception about this case. He has no open mind to the defense that these defendants intend to put on. He has stated in chambers that he doesn't want to hear anything outside of Pennsylvania, even to the point of ignorance of thinking that what went on in Nazi Germany, or what went on in Hiroshima and Nagasaki, that these things have nothing to do with Pennsylvania law, as if the events of the world have nothing to do with Norristown and Montgomery County and the Commonwealth of Pennsylvania. We're not here living in a vacuum. We're here as part of the world community. And everybody in this county is as bound by international law as all the people living in Bavaria and the entire range of the Third Reich. And I think that to hold those people accountable and to assume that we will not be held accountable is ridiculous. And but worse than that, from a lawyer's point of view, to say that you have a preconception about how we're going to prove our justification defense, it rules out any possibility of fairness on this judge's part. But the judge, for example, today is holding a night session. You know, it's early morning now for us. We're going to go through a day until 10 o'clock tonight in which jurors are going to get cranky. They're going to blame it on us. They always do. That's the risk a defense always takes when they have a sequestered jury, which we don't have. But it's worse than being sequestered if you're made to work until 10 o'clock at night for no good reason. We have not been holding up this trial. It took a week to pick a jury because every honest juror who came before the panel here conceded they knew about this case. And they conceded that they had some opinion about it. Well, you know, it takes a while to sift through that. And it's very important to us to get a fair jury. But the frank answer is that I think there has been error. I think the judge has interposed himself too much in the selection process. And I think that he made error in the questions that he would not allow to be asked. And I think we did not get a fair jury. And that's as far as we've gotten so far. Thank you.
You want to go cut away?
Yeah,
We have to go around.
Mike, can you stay? You can just keep talking.
Is Ramsey here?
Yeah.
I hope he has the discovery motion.
Yeah, because I think we can represent that it was in
Part of
informal
it.
discovery.
Yeah.
These things about witnesses and so forth came
Sure.
up.
And,
I'd also like to talk to him about this juror number 1.
Yeah.
And
What do you know?
I'd like to know whether the court is aware of her relationship to the judge.
That's the problem.
Maybe writing.
One more. Take you look at it.
Stop, I guess.
Okay, sure, because that's what we're always doing.
That's what we're always doing.
Love to
Isn't that
do
what
it,
lawyers
actually.
do?
Actually, it's very hard to be in that courtroom and not talk, I'll tell you.
Oh.
Very unnatural.
I don't get through the day without doing it. I finally, yesterday, toward the end of the day, the judge announced the night session. So I thought, well, saying how he has had
Right.
other good trials and this and that. And it was just on my mind because Dan Berrigan had asked me for the editorials that had appeared in the bulletin. They're very uncomplimentary to the judge. Quite accurate, but uncomplimentary. And they were on my... Good for you.
And he's appearing before the Pennsylvania Supreme Court.
Yeah,
with,
I know.
with or what?
Watt.
With what?
I think Watt.
And the district attorney has him in.
Oh,
on
he
that
did
same
go?
flight.
Oh,
Oh, yeah.
good.
Ron Williamson, a tall, slim fellow?
It's a guy whose wife has a sports car.
No,
'cause they do it-
I saw him downstairs. The guy you introduced
We're
me.
going to do... Say it again.
But I'm not going to